Welcome to the Fox Williams Forward Thinking podcast on common IP misconceptions for World IP Day on the 26th of April 2026. My name is Scott Steinberg and I'm joined by
Lucy Marlowe.
And let's get going. So what are the common IP misconceptions that you've heard?
So often clients think that if they have a company registered at Companies House or a domain name, that means that they have protection for the name itself. And obviously they don't. So you still need, in order to stop third parties from using a similar trademark, then a similar brand, you need to make sure you have a registered trademark.
But what about if no one has a registered trademark? Can you use it?
You're still at risk. So in the IP world, there are rights such as passing off that parties who've been using the mark for longer than you can acquire and use those rights to stop you acquiring a trademark, or they can claim passing off.
Another one related to that is, when a client will have a UK trademark, but unfortunately, or fortunately, depending on who you speak to, trademarks are territorial, so that won't cover you in other territories, such as the EU these days.
And often clients think that just because they have that UK trademark, that they can launch globally, and actually earlier rights holders, like we just mentioned, can exist, and that can actually block you from entering that territory. So in my experience, it's really helpful to do a global prior rights check before launching your brand in all the territories that are of interest to you, so you don't end up with that patchwork of rights.
Didn't that happen with Links and Axe? Because they've got different names in different countries.
Meta.
Oh yeah. So you have to be careful no matter what size your company is. And then another one is, I've come up with an idea for something. Can I protect that idea?
Well, that's another misconception, which is that ideas themselves are not protected. The idea is protected once it's expressed. So if you've recorded that idea to text, so if you've got words, if you've got images, then those are capable of protection, but the ideas themselves are not.
No, but what about if I pay someone to create something? I mean, this is a common one and it makes sense, right? That you would think if you pay someone to create your website or to take photos for you, you'd think that you would own those IP rights, but that's just not the case.
No, you need a written assignment and that needs to be well drafted to ensure that the IP that's created is assigned to you as the party that's paid for those services. So what about collaborations, Scott? What have you seen there? Should I be careful when disclosing my idea to a party that I might collaborate with?
This is the key one really, because some IP rights rely on when the information was first disclosed, so such as patents or designs. So please, if something is really confidential and important to you, have a confidentiality agreement or a NDA or a non-disclosure agreement to cover that. What about if a photo's online? Can I use it?
Again, you have to be careful with that and check the terms of the licensing. Often a license may be granted for private use but not commercial use, or it allows use in certain jurisdictions. So it's important that you look at the terms of that license before using. And if you are granted a license, then again, keep a record of that so you have proof of the license terms.
Records are key, aren't they, for copyright? I mean, a common one, or relatively common that we hear, is about, if I post this copyright work to myself, then it's protected. But that's another misconception.
Yeah, you need to keep a record of how the evolution of your idea. So let's say it's a script for a book, all the different iterations need to be recorded so you can show how you came up with the original design, the original text, and that you can show that it is original, because that's a significant test when it comes to the subsistence of copyright. What about copyright infringement, Scott? If I see a drawing, say I'm a clothing designer, and I see a drawing or a design that's out there that I really, really like, and I'd like something quite similar, can I just make one or two changes and get away with it?
You can do if you want to get sued, but really, the test is not how many changes should you make. It's a test of what sort of, did you copy the whole or a substantial amount? And that's more of a test of quality rather than quantity. So unfortunately, it's one of those where it depends on the fact, which is a very lawyerly answer that no one probably likes.
But again, coming back to that, if you can show independent creation, so even if the end product is quite similar, if you were not inspired by that and you independently came up with that particular design for a pair of trousers, for example, then you're on the right side of the law.
Yeah, don't copy, please. What does patent pending mean, Lucy?
So that means that you've filed a patent, but it's not yet been granted. So at that point, you don't yet have enforceable rights. You'll often see products with a stamp, let's say, on it saying patent pending, and that's mainly there to act as a deterrent to stop people from thinking that they can create a similar product that might otherwise infringe the underlying patent. So if I have a registered design, what does that mean? Does that mean that it's valid? Or can you just tell me a little bit about that? Because as we know, this is something that clients often think, is that they've got a registered design and then that's fine, they can enforce it against anyone. But what do you find takes place there, Scott?
So interestingly, the UK has taken a decision that they won't sort of assess some of the requirements for design, such as, is it novel enough? Does it have individual character? And so on. So technically, you may have a registration that is not necessarily valid, and it's then for a third party to prove that it's not valid. So yeah, please be careful how you register your designs.
And often it's about the strategy with the filing. So sometimes identifying a specific part of the overall design that you want to claim protection will put you in better position for subsequent litigation. And that overall strategy is what we help clients with all the time, is that so to ensure that their design rights are as valid and enforceable as possible.
Well, hopefully we've answered some misconceptions now, but I think we may have led to more questions and queries from people. But yeah, that's everything on our misconceptions. You have no misconceptions anymore. But if you do, feel free to get in touch.
Thank you.